We're going to go on the record in State of Kansas versus Justin Bishop. This is an old Elk County case, 2023 CR 000004. The state appears by and through Ms. Gillette, Elk County attorney. Mr. Bishop appears with his court-appointed attorney, Mr. House. We are scheduled for a revocation hearing today. Ms. Stanfield has filed an addendum to the original warrant, as well as the original warrant in this matter. Mr. House, which I believe was filed July the 3rd. Anybody can correct me if I'm wrong. Mr. House, does your client wish a hearing on these alleged violations?
Your Honor, if I could have a breakout room with him for just a few minutes. I just discovered he was in Butler County Jail yesterday. He had not contacted me. And I have prepared for the hearing this morning, but I do need to talk with him.
Okay, and let the record reflect, Mr. Bishop does appear. He is in custody in the Butler County Jail, and he is appearing by Zoom. They have accommodated us for this Elk County hearing, which I appreciate. All right, I think I don't have anything till 11, if I'm not mistaken, so I can give you about 10 or 15 minutes at the most.
10 minutes will be fine, Judge.
All right, we are in recess. All right, we need to bring everybody back in and get started. So we have enough time to conduct a hearing if we need to.
I just closed the breakout room, so it should notify him to come back.
Okay. How long has Mr. Bishop been in custody?
0 days on our case. All of it is over at Butler.
I guess maybe he doesn't look in, have mine or something. Mr. House, we need to get going if we need to have a hearing.
We're ready to proceed, Judge. There is one matter I want to take up before we start evidence in the case.
All right.
I've talked with my client, Mr. Bishop. He would request that the case be continued until the new Butler County cases have been resolved, because these are just allegations and they hadn't had a chance to come to trial yet on them.
Well, there's other things besides the new charges. Ms. Gillette, are you aware that if we don't have a conviction, that we need some officers and some preponderance of the evidence finding, or are you wanting to just proceed on the other matters, or what is your intention here?
There's also a requirement that he report law enforcement contact to his ISO, which he was not doing. And that's notated in the warrant that he was not informing her when he was having all of this law enforcement contact. Also, he absconded, got kicked out of treatment, unsuccessfully discharged.
I'm just asking you if you want to proceed to hearing today.
Yeah, I think
without the convictions, or do you have officers lined up to testify with regard to the court making a preponderance finding? I don't need a beyond a reasonable doubt on these charges, just a preponderance.
Right. I believe we have enough other issues with him that we're able to proceed.
All right, you may call your first witness.
Your Honor, we'll call Teresa Stanfield.
Ms. Stanfield, if you'd raise your right hand, you do solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, I do.
Thank you. You may proceed, Ms. Gillette.
And Miss Stanfield, are you the supervisor? Could you first please state your name for the record?
Yes, Teresa Stanfield,
And how are you employed?
by 13th Judicial District Community Corrections.
Are you the supervising officer for Mr. Bishop?
Yes, I am.
And has he had prior revocations?
Yes, he has.
And as you've been supervising him, has he had violations since you've been having him on supervision?
Yes.
I want to talk about those violations. I want to start with his original and not the new additional violations. Has he been having violations of the law where he's been arrested?
Yes.
Has he been reporting those to you as he is supposed to?
No.
Has he reported any of his arrests to you?
He may have, I would have to look back. He may have reported on the warrant, the case that was filed on June 11th. I believe when that did occur, which was back in November or December, I believe he did tell me about that one.
Okay.
But otherwise, let's see, the next one, he did tell me about the next one, the driving while suspended and driving without a tag. He did tell me about that one, but those are the only two that he ever reported to me, law enforcement contact.
Did he report his interactions that would have been in Butler or El Dorado Police Department case number 2501026?
No, he never notified me.
And did he tell you about the July 2nd, 2025 El Dorado Police 2501043?
No, he did not.
And on your addendum that you filed, did he tell you about the addendum ones that would be 0 or 2501035?
No, he did not.
Did he report case 2501082 to you?
No, he did not.
Did he report 2501187 to you?
No, he did not.
And did he report 2501168 to you?
No.
Was he able to successfully complete treatment during this extension period?
He did complete outpatient treatment and then he was transferred to relapse prevention. He did not complete that and he was unsuccessfully discharged on July 31st.
Okay. Well, where was he attending that treatment at?
SAC, Substance Abuse Center of Kansas in El Dorado.
Now, did he miss appointments with you?
Yes, he did.
What appointments did he miss with you?
He missed June 6th at 4:30 and June 30th at 4:30.
Did he report after the June 30th, 2025?
No, the last time I saw him in the office was June 16th.
And did you go to his residence to try to find him?
Yes, I did.
When did you do that?
That was on July 2nd.
And what did you find out when you went to his residence?
I spoke to a gentleman that his name was Eli, and I asked him if he was his son-in-law, and he said yes. And he said they had kicked him out of the house about a month and a half earlier because things were just not working out.
Were you ever given a new address for him?
No,
Were you given a new phone number for him?
No,
Were you given any new contact information for him?
no, I wasn't. Well, I guess I should say, when I talked to his providers, they had told me that he was homeless and thought he was staying under a bridge somewhere here in El Dorado.
And were you told about his arrest for 25-01026 by the El Dorado Police Department?
Yes, I was.
Did he ever provide you verification of employment?
No,
Did he ever provide you any verification of making payments towards his court case?
no.
Your Honor, I will pass this witness to the defense.
All right, Mr. House, cross-examination of this witness.
Yes, Your Honor, thank you. Ms. Stanfield, you indicate he missed appointments on June the 6th and June the 30th. Since we were last in court on the previous motion to revoke, do you know when that was?
When the last hearing was?
Yes.
The disposition hearing was April 10th.
And how often was he to meet with you? Was he meeting weekly,
No, he came in every other week.
every other week? Did he come in both meetings in April?
On April 8th, he called in on that time. And then we had the hearing on April 10th. And then April 23rd, he reported an hour late. So I only actually saw him in person one time in April.
And then in May, what did you see him?
He reported on May 8th and filled out a walk-in report because I was sick that day. So, but it did count as an appointment. And then he did report May 23rd as directed.
And then he's been in jail during July. Is that correct?
According to VineLink, he's been in jail since July 25th.
Well, I'll have him testify as to the time he went in jail. And I'm not certain when it was. As to his inpatient treatment, then he did complete it.
He did inpatient probably over a year ago.
Okay, and he completed it.
Yes.
And he was doing outpatient treatment through SAC.
Yes.
And is he doing outpatient treatment through SAC now, or at least treatment through them? Are they seeing him?
I don't know. He's in jail. I don't.
Okay.
He was unsuccessfully discharged on July 31st when he was still out of custody.
On July 31st of this year?
Yes.
Wasn't he in jail then?
Yes, but I mean, that's when I got the discharge report from them was July 31st because they hadn't seen him for 3 weeks.
All right. And again, I'll have him testify as to when he went in jail. Did he pay $100 on the costs at some point after our last probation hearing?
I don't know. He's never provided me verification. He's never brought me in a receipt.
Okay. And was there one time that he and maybe you've testified to it, that he did report and filled out a report, and maybe that's the time you were sick.
Yeah, May 8th, I was ill, so he filled out a walk-in report.
Okay. Well, first of all, I want you to understand, I'm cross-examining you now, but I recognize the efforts that you've made in the past to help Justin with his probation. So just want that said. As far as the police contacts, then you don't think he reported hardly any of them except maybe one?
Possibly two. The driving while suspended and the meth case that happened last December or November. But these current ones, he has never notified me of any law enforcement contact.
So the December meth case, where was that case at? In Butler County?
Yes. But at the time they didn't charge him, they were waiting on lab reports. So they recently had charged him with it.
Okay, but we were all aware then of that case. It just hadn't been resolved.
Correct.
So it's nothing new as far as evidence on this case since the last probation, other than that it's been resolved now.
It's been officially filed now. That's why it's been officially filed.
Okay, all right. I think that's all the questions I have, Judge.
Any redirect of this witness, Ms. Gillette?
I don't believe so, Your Honor.
All right. Any further witnesses you wish to call today?
No, Your Honor.
All right, Mr. House, do you wish to call any witnesses today?
Yes, I'm going to call Mr. Bishop.
All right, Mr. Bishop, raise your right hand. You do solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, I do, Your Honor.
Thank you.
Okay, Mr. Bishop, as to the inpatient treatment program, you did complete that, is that correct?
Yes, sir.
And on the outpatient treatment program, where did you go?
I went to SAC in El Dorado.
And when did you start that, if you know?
I don't remember exactly, but I did give Ms. Stanfield a copy of the certificate in which she said, "I am very proud of you, and I don't think the judge will believe that you completed it." We had a report that was pretty good, pretty transparent. She was aware of all of my personal deals. I would explain to her, and she would say things like, "You don't deserve that, Justin. You need to move on," this, that, and the other. We spoke about relationships, the feelings, that occur in a relationship. She knew that I had started the extended aftercare, was doing that. On the 3rd, when this warrant was filed, I was in SAC. She told me they had a faulty specimen cup, and she reported that if I didn't stay there and take the test, it would be taken as a dirty UA. So I went ahead and took the test. I hadn't.
And when
No.
you say on the third, what month?
It was July. I had a city case that I had to appear on, and I had the warrant was already issued for KODC, and I wasn't arrested at court or anything. I was given a list of places where I was trespassed from at my residence.
As to
Let's be clear here, just for the record, July 3rd of 2025.
Yes, ma'am.
All right, go ahead.
when did you go into the Butler County Jail on these new cases?
Latter part of June.
Of June or July?
July. Excuse me, July.
Okay, so Ms. Stanfield's probably correct if she says it's sometime around the 27th.
Yeah, I think it was a little bit before that, actually, to be sure.
Okay. All right.
I thought she said the 25th,
Well, and you're probably right too.
the 25th.
All right.
And she referred to Vine link. Now, Ms. Stanfield, just for my information reference, Vine will pick up incarcerations in other county jails other than just Butler.
Yes.
So it helps you figure out where people are within the state and various county jails if they're linked to mine.
Yes.
Thank you. Go ahead, Mr. House.
Thank you, Judge. Mr. Bishop, your new cases, did you report any of these cases to Ms. Stanfield?
I think she was aware of the first one, when the first one occurred. The second ones I accumulated quite quickly and didn't see her. I was pretty much distraught about the situation. I was told to leave the residence. I was accused of domestic violence, which I didn't do.
Is this when you were staying at your granddaughter's,
No, this was at my girlfriend's house.
at your girlfriend's house? And what's her name?
Her name is Cassandra Warren.
All right. And is she the one that got a PFA?
Yes, sir. Yes, sir.
And is she the one that you're charged with various crimes?
Yes, sir. Yes, sir.
Protective order?
Yes, sir. During that time period, we had a flash flood here in El Dorado, and the circumstances, the conditions weren't very, very good for myself.
Were you living with her at that time?
Yes, I was, Your Honor. Or yes, sir.
And how long did that last?
I was there. We've been together for 4 months or 4 years. The last 2 months were pretty rocky. I was open with Teresa about the circumstances involving my relationship, which were pretty detrimental. STDs, exposed to hepatitis, HIV, quite stressful situation.
So you all, of course, are separated now, and you report any of the negative contacts with law enforcement concerning your relationship with her?
I think one is all sir. It was one when it first happened. Other than that, I didn't report them to her. She knew about them through SAC. I was very transparent with SAC and her also. They were sending emails. I have an email that Miss Nelson gave me last week here in jail of her response to coming out and see me. I asked her if she'd come out and see me. She said she wouldn't come out and see me.
Did you have any temporary work during this period of time since our last probation hearing?
Temporary work?
Yes.
Yeah, I've had the same employment. I gave Miss Stanfield a letter from the landowner where I work at, and Miss Stanfield said that it was faked, that I had Cassie write it. And when it came down to it, she said that she had looked at both handwritings, Cassie's handwriting and the note, and came to a conclusion that it was false. We remedied that situation. I gave her the address of the landowner. She found out that where I was working at, what I had been doing. I was trying to get my Social Security card and my birth certificate in the last 2 months and getting my driver's license established, which I've done that. There were quite a few obstacles in my way that I was knocking down during this time, besides the personal relationship problems.
So do you have your driver's license now?
No, I have the information resolved with the counties, except for the SR-22, which I used the funds to bond out of jail with.
All right. Was there anything else you can tell the court as to what you've done in a positive fashion to work on your drug problem since our last hearings? Have you continued going to AA or NA
I've
meetings?
continued to go to AA. I've been past a year sober. I would go to my meetings with Teresa in a great attitude. In the past, I was scared to go to it because I was dirty. I've been clean for over a year. Everything was going good besides my personal relationship, and finding myself throughout this a place to belong in society's been a little bit different. You know, we talked about being a counselor. It's one of the great things I do know a lot about, addiction. And she suggested you have a great personality. You should pursue that. And that's what I was doing. Since I've been in here, I've taken classes. I've enrolled in GED. I've seen my SAC worker, Miss Nelson, numerous times since I've been here. I'm kind of surprised she's not in court today. She'd be a great witness.
Your SAC representative that sees you is who?
Her name is Ashley Nelson.
All right. So you've done that and you've continued with the NA meetings, AA meetings.
Yes, sir.
Uh,
I've fallen off the NA meetings because Cassie leads those meetings, and with the PFA, I can't attend those meetings. That's been kind of a thing that happened. But I've continued to stay clean and sober, going to AAs, going to Wichita to AAs. I failed during this last personal issues to keep Teresa up to date on those. Yeah, I have been having a rough time at that, but I've made payments. The last time I was arrested in Elk County, I went over to the courthouse, made a payment. It
how much was that payment?
was $100.
All right, Mr. Bishop, anything else you want to tell the court?
I'd just like to thank everybody's contribution to helping me stay clean. Ms.
How
Satterfield,
long,
I appreciate the chances. Pardon?
how long have you been clean?
Over a year now. Over a year. Year and 7 months.
That's for drugs and alcohol,
That's
right?
drugs and alcohol, sir.
Judge, I think that's all the questions I have.
All right, cross-examination, Ms. Gillette.
Mr. Bishop, did you report on June 6th, 2025 at 4:30 PM like you were ordered to?
I don't remember exactly if it was June 6th. I'll trust Miss Stanfield of keeping the records. If she says I didn't, I must have missed, or I did call in.
Did you report on June 30th, 2025 at 4:30?
I think I was in jail that day. Not sure.
Did you report anytime in July from July 1st to July 25th when you were arrested?
Yes, I reported via SAC. I was on the telephone with her, and I rode my bicycle over to see her.
And are you sure that that was in July?
Yes, ma'am.
Were you aware that she went to your residence and you weren't there anymore?
Yes, we talked about that. Twice she went to my residence. One time it was a younger gentleman, a kid that was staying with my family. He was visiting from another state. He didn't know who Justin Todd Bishop was.
Were you aware she went and you weren't there? Did you give her a new address after you were kicked out of that house?
She knew because of the summons that was put on the door.
Were you aware, did you report your law enforcement contact on July 2nd, 2025 when you were arrested for violation of a PFA interference with law enforcement officer and stalking?
No.
Did you report your law enforcement contact on June 27th when you were arrested by the El Dorado Police Department for domestic battery?
No.
Did you report any of your arrests in July?
No.
Did you have a relapse and be sent to the relapse assistance program?
No.
Did you end up having to be ordered to go back to SAC for inpatient treatment for relapse?
No.
Were you unsuccessfully discharged in July from SAC?
Through the aftercare program, after I completed the initial outpatient, I was taken off of it, but I'm currently re-enrolled now.
And were you arrested with possession of methamphetamine and marijuana paraphernalia?
Back in December on that WAP charge, not a new case, no.
And did you ever give Miss Stanfield any paychecks that show you had employment or being paid legitimately?
Yes.
What paycheck did you give her?
I don't receive paychecks. I gave her a letter from the landowner.
The question was, did you turn in a pay stub paycheck?
I don't have a pay stub.
Have you made any payments on your cost or restitution?
Yes, I have.
When were those made?
Right after I was released from the Elk County Jail last time I was arrested.
Okay. Have you made any further payments since you were arrested in Elk County when you paid those to try to get back on probation?
No, I haven't. I've been incarcerated and I've been here in El Dorado.
Before you were incarcerated, from July 1st to July 25th, did you make any payments?
No, within those 20 days, no, I didn't.
Did you make any payments in June of 2025?
What is my release date from the county jail? I just told you that's whenever I made the only payment.
And during July 1st through July 25th, when you were not in custody, did you try to contact Ms. Stanfield personally without any help from SAC or anyone else, or while being in jail, to report to her?
Yes, I did.
What date and time did you try to do?
I'm not sure on the date and time, but I made a phone call out there to him, spoke to Adam.
Your Honor, I will pass this witness back to Mr. House.
Any further redirect?
Just one question, Mr. Bishop, you were working for who? What's his name?
He's a landowner out in Butler County.
Okay. And what kind of work were you doing?
I was cutting firewood. Miss Stanfield found his name on the county registry of the land that he owns.
And that's where you were working, and then you were selling the firewood, right?
Yes, sir. Yes, sir.
And when's the last time you cut wood?
Last time I cut wood was in May.
You've never been asked to give a UA?
Yeah, I've given several clean UAs. The last UA that I gave that was not clean was to Miss Stanfield. I had Delta 8 in my system with no methamphetamine. I've never given a dirty UA in the last year.
All right. That's all I have, Judge.
All right, well, Mr. Bishop, it's clear to me that you violated the terms and conditions of your probation that I established for you back on November 2nd of 2023. This is what I view as an old case, that you were up to 18 months on probation and could have completed sooner. Actually, you were on 12 months because you didn't. I'm not sure that you were a Senate bill case, even though you've gotten lots of what we refer to as Senate bill treatment. So the case was not paid off in 12 months. I find that you've not completed the aftercare as recommended, that you've not paid your case off, and that you've not reported, and that you've not reported new contacts and arrests directly with Ms. Stanfield. It isn't her job to be a detective and go through various folks to learn about you. It's your job to directly inform her and to report as ordered by this court. And you know the drill. You've been doing this for quite some time. You've had several revocations previously, and you were a departure that you're not even entitled to any intermediate sanctions. Now, I will briefly hear from counsel as to recommendations as to disposition of this case, starting with Ms. Gillette.
Frankly, Judge, we've given him 2 prior chances. This is his 3rd revocation. He's continually just out there breaking the law. We have utter failure of almost every condition of probation here. Dirty UAs, we have no proof of employment, no payments, unsuccessfully discharged from his aftercare treatment, numerous contacts with law enforcement not being reported, not staying in the same place or updating address and phone number, absconded again, no new address. Now, he keeps saying, I haven't had any positive UAs in the last year. Yes, he did when we were here last time. That was, his disposition was in April of this year. April 10th of 2025 was the date that we had his journal entry and his last hearing. That was only 3 months ago, and all of these other failures have happened in the last 3 months. We've heard the same promises over and over again, the same excuses. We've had to have evidence over and over because he doesn't accept responsibility for his own actions. Choices have consequences. I say that over and over. My choices have consequences for me. Mr. Bishop's choices have consequences for him. And we have given him 2 extra chances. I ask that he serve his 34-month underlying sentence. We've been here 3 times now for his utter failure in choices that he is making. And the last 3 months have not gone well for him. The only time that he does well is when he has a revocation pending and when he's in custody. And he needs to find his treatment while he's in custody, take advantage of the programs that are offered from KDOC, and hopefully come out with job training and treatment under his belt.
All right, Mr. House. Ms. Gillette, do you have any idea what his jail credit is?
I do, Your Honor. He has 0 extra days. I have him down for 61 days of credit. That was from a prior stint in for a jail sanction. And it was journalized on a prior journal entry.
All right. Mr. House, recommendations?
Your Honor, I know the court's indicated this was a departure case. I think his criminal history is B. And that's probably why he wasn't able to get Senate Bill 123, although he's had several drug treatment programs that he's been in. I can request on his behalf that you sanction him for 60 days and then that he be placed back on probation. I understand that if that doesn't happen, he's got 34 months to serve, less 61 days credit. And I've advised him he has 20% good time available, which would be 6.8 months. And I've advised him of programs, and he knows about the programs at KDOC that he might take advantage of. But the request would be that while he still has bumps in the road, he continues to be substantially clean of drugs and or alcohol. He continues to work with NA and AA programs, and while it's been tough, he still does positive things, and that's our request today.
All right, Mr. Bishop, is there anything that you want to say before I impose your sanction or your sentence?
I have the technicalities of the case, Your Honor. They are true. I have given you gave me a new lease on life, the opportunity to stay clean. I've done that besides the one Delta 8 incident for THC. The personal stuff going on in my life, I really was distraught when I was making those decisions, breaking the PFAs, and I know that looks bad, but that's about all I got to say, Your Honor. Thank you for your time. Teresa, thank you for your help. And if you feel that I need to go do my underlined sentence, then maybe that would be the best thing for me. I'm aware of the opportunities, the medical stuff, the minimum camp, getting a job, afterwards, housing, becoming institutionalized and not being able to function in society, perhaps. That's what I need to do, then that's what I need to do.
All right. Well, I appreciate your statements. Mr. Bishop, you always put forth a good argument and posture during these court hearings. There's no question about that. That's why I've multiple times afforded you probation when I maybe normally otherwise don't or wouldn't. That includes departures when folks are A and B criminal history categories. So that departure was a big leap way back when, and you knew that when I did it, and I lectured you like I would anyone if I find substantial and compelling reasons, and that included a finding that I didn't believe that there were any public safety issues with you at all. Since that time, we've been down this road before, numerous revocations. You get it together, you get people to vouch and advocate for you, including Miss Stanfield, including Miss Nelson. I recall at one point when you were in Winfield, you were doing pretty well, but you chose to come back to El Dorado, and you've made your choices, and they haven't always been good ones, but we've been through the same song and dance, and frankly, I'm at the end of my road with you, and you just lack complete follow through, and it's something, it's always something, and you always explain it, but the point is, this is a case that you should have completed your probation. You had the ability to do it and the wherewithal to, and you haven't. So what happens to people, anyone who don't complete their probation and their sentence, especially when they're a departure case, is they serve their sentence. And that's what I'm going to order for you, that you serve your 34 months. It's not a judgment as to what, I don't have to make special findings why you should be incarcerated or serve your sentence. You're ordered initially a sentence that unless you complete probation, it's presumed that you're going to serve it. So you are entitled to 20% good time, 12-month post-release, and all your jail credit. They say it's 61 days. I'd ask Mr. House to look the journal entry over, double check that, make sure that you're getting full credit for any time in this case that you should be entitled to. And I would appreciate it if Ms. Stanfield would check to see if there's any other time that should be counted, and let Ms. Gillette know. I have every intention of giving you all of your days of credit. You have 14 days to appeal. I will let you make $10 a month payments while you're incarcerated. If you miss a payment on your case, it will be referred for collections. So the reason that is done is because the Supreme Court says I have to give you a payment plan when I send someone to prison, anyone, and I have to give you an opportunity to pay, and you have to violate that payment plan for your case to go to collections. And my view of that whole thing is that there are contract agencies. One I can think of is Butler and Associates, and it's not Butler County. It just happens to have the name Butler. And so there are collection agencies and attorneys that now in the last, I don't know, 5 years or so that I remember, go after any inmate funds that you have, whether it's through some kind of work, in-house or a work program. And sometimes even monies you get from family or inheritance or whatever the case may be. And then you don't have any money for the commissary or hygiene products and that kind of thing. So the point is, if you'll make $10 a month payments, you'll protect any other monies that you have for extra soap or whatever it is. I'm not in touch with the Department of Corrections. I lose jurisdiction and I'm not sure what all of their rules are, but that's my understanding of why I'm giving you a payment plan that may seem silly to you, but
I understand, Your Honor.
that's what I'm ordering. All right. Is there anything further, counsel?
Judge, I need to have you announce.
I'm waiving
Thank
attorney fees and any bids fee or any extra
Thank you, Your Honor.
additional costs.
And
Anything?
those costs will be paid to the District Court of Elk County. Is that right, Judge?
His previous, well, I'm not sure what you're asking.
The $10 a month that you order him to pay,
Yes,
costs will be paid to the District Court of Elk County, Kansas.
yes, yes. All right. Good morning, Mr. Cooper. Are we ready to get started here?
We are, Your Honor.
All right, we're gonna go on the record in state of Kansas versus Colin L. Camp, 2022 CR 9, Elk County District Court. Colin is COLIN, 1L, middle initial L, and then Camp. This is a warrant to show cause hearing. Mr. Camp was on interstate, was an interstate compact to Oklahoma. They requested that his probation be reconsidered and or revoked. He is on a no bond hold because that's the requirement of interstate compact. He is in Elk County custody. On July 24th of 2024, state of Oklahoma reported that he had not completed an alcohol drug evaluation and that he had not completed mental health or his domestic violence assessment as ordered by this court. I have a copy of his intensive supervision agreement. I believe there's been one previous revocation even. Yes, that was back in December of 24. I think this is a separate one from July of 25. And I'm trying to look here. It is journal entry of conviction if I have it here. Or I'll just look at my notes. Yes, he does have a prior. Revocation. This is 22 CR 00009. It's very old, Mr. Cooper. Ms. Gillette appears on behalf of the state as Elk County attorney. Mr. Cooper is appearing with Mr. Camp. Here's his journal entry. He was an I on an aggravated battery. Date of conviction, November 14th, 2022. He was presumptive probation. He was granted probation. I assume I gave him the 12 months. I'm not sure how much credit for time served he has total to date, but at any rate, announcement to the court.
Your Honor, I've had a chance to speak to Mr. Camp prior to today's hearing. I went over the request for revocation that was filed on July 30th of 2025. there are 2 allegations. I've detailed those allegations with Mr. Camp. I also received from the state of Kansas a violation report, Interstate Commission for Adult Offender Supervision report yesterday, giving some more detail about it. This is from Oklahoma, and I've gone over that with Mr. Camp as well. Mr. Camp tells me at this time, Judge, he is going to waive his right to a probation violation hearing. He is going to admit to the 2 allegations.
All right, is that true, Mr. Camp?
Yes, ma'am.
All right, I am going to fine you in violation of your community corrections placement in this case. And I will ask for before I visit with you, I'm going to ask for recommendations from council, starting with the county attorney.
Judge, I've struggled with whether I wanted to ask for further sanctions or ask for his underlying sentence in this matter. Mr. Camp was told at his first violation hearing that this was his one and his dip and no more are required. What gives me concern is that the parties from Oklahoma reported that the relationship was so bad and the behavior was so bad, they were afraid of him. That gives me a lot of pause for concern, especially since this is not a drug case. This is a violence case, aggravated battery and domestic battery and paraphernalia. When he was back here on his prior probation violation, it was because he, again, had not done his drug and alcohol evaluation or his getting his BIP assessment done and getting into those classes. Both were needing to be done within 90 days. He promised he would get those done in 90 days. We're back here. One of the reasons this case is so old is we had to revoke his bond. And his case drug out at his own issues during the pendency of the action. It appears that Mr. Camp chooses to disobey the orders of the court, both on probation and on bond. Again, I've said this today, but that was a different hearing, and I'll say it again. Choices have consequences. My choices have consequences for me, and all of our choices have consequences for ourselves. Mr. Camp has not gotten his evaluations done. I know that Ms. Stanfield and her counterparts in Oklahoma will give numerous recommendations, and they gave recommendations to him according to the sheets that were given to us for his violations, and he didn't want their advice. When you're getting advice from those people who supervise you, that advice is very important. And those choices to not follow their advice are the same as disregarding the court's orders, as he did throughout the whole pendency of his case and on his supervision. When you choose not to follow the court and you choose not to follow those who are supervising you, you make a choice that you want to go back to jail or to prison. The question is for how long. His underlying term is 12 months. I know that he has significant jail credit. At his last journal entry, he had 151 days. Today, he has 165 days in. He was arrested August 7th. I have calculated his jail credit to be 14 days from 8/7 to today. He already had the 49 days, and when you add the 14, it comes out to be 63 additional days with 102 at the time of original sentencing. That brings us up to 165 as today. With those numbers, he's done half his sentence already. If we make him stay in custody, and get the BIP assessment from in custody. And I don't know if they travel to do those. And he gets his drug and alcohol evaluation while in custody, that he will follow the court's directions to complete any assessments he would get done. Since he's been in there, he could have made arrangements or scheduled those while in custody, but nothing's been done that direction. I don't know that I have much choice but to ask for his underlying. As I said, he's completed half of his 12-month sentence, just because he's made choices not to follow any court orders in this case from the beginning.
All right, thank you. Ms. Stanfield, do you know how much he owes in this case by chance?
Your Honor, I have his case pulled up on my system. He owes $807. There was an adjustment of $200 and one case payment of $51 on July 27th, 2023.
Okay. Was any of that is any of it restitution?
On the original journal entry of judgment, there was no restitution ordered. We took off a $200 fee somewhere that was adjusted off after this. I don't know if it was DNA database,
Okay.
what it was.
All right, thank you. Mr. Cooper, recommendations to the court?
Well, Judge, I think a lot of what Ms. Gillette stated, especially in terms of the credit, the time he has in, is correct. Mr. Camp would disagree with some of the details of how this kind of came about and whether or not, of course, he was any kind of threat to anybody. But the bottom line is the assessments haven't been done. I talked to him about why. He tells me that the main issue was a money issue. He called around to several places. The cheapest he could find was doing total for all the assessments was $300+. He just never had that kind of money. He was living with these individuals, working for them, and sort of, as he described it, sort of trapped there at work just because he had no rides, had no availability to get anywhere to get them done anyway. So he said he wished if he had known how difficult it was going to be to get these things done in Oklahoma, he wouldn't have gone. He's just kind of been stranded there, for lack of a better term, I think would be the way he would describe it. He tells me he has $136 on him in property at this point in time. His plan would be, Judge, if he were to be placed back on probation, and that's what we're going to be asking the court to do, would be to live in Granola, Kansas. There's a trailer at his grandmother's. We have a specific address we could provide to the court, but it's in Granola. He believes a pastor of the church there in Granola could transport him to Wichita for these assessments. He would use the $136 toward that, and that's where he would at least reside for now. So that's the plan. I think Ms. Gillette is correct. He's probably done about half of his sentence, and of course there's good time credit he could earn. So he could earn probably another couple months off of his sentence. So there's not a lot of time that he would have left if the court were to send him to DOC. I don't know if it'd be worth it to Your Honor to try to take one more chance to see if we could get Mr. Camp the help that obviously he needs. He's just had a lot of difficulty getting it done. I know he would like to for that opportunity, and so we're asking the court to do that. If the court's not inclined to do that, I would ask the court to consider just the idea that he's got so little time left at this point in time, maybe to consider some reduction in the sentence so that he could be done with this and go and be done. He could go on to post-release and start getting this situation behind him. As the court noted, this is an old case. It's been going on for quite some time. don't think there's any, I mean, there's no allegation of new crimes being committed or anything like that. It's a difficult case because it's clear to me that Mr. Camp needs this help. It's just been, for whatever reason, one reason or another, just difficult to get done for him at this point in time, Judge. Thank you.
All right, thank you. Mr. Camp, is there anything that you want to say before I impose your sentence?
I don't want to make any excuses as to why I was not able to complete the obligations of the court. I just need to do better. If given the opportunity, I would do my best to get this stuff handled.
Okay, well, I think you would, I certainly think that you would desire to do that. Whether or not you would, I don't know. But if and when you are released and you're not given direction, where would you go? If somebody wasn't telling you where you had to go, where would you go?
I would probably get a hold of Miss Stanfield and ask her. And if not, I would, from what I understand, my mom told me that I need to do the mental health assessment with Fort County, and then I need to go to a certified domestic violence assessment center in Wichita.
Okay. Well, I wish you would have brought this plan forward at your last revocation hearing and not went back to Oklahoma and stayed here committed to completing your probation. But Ms. Stanfield, unless you feel strongly otherwise, frankly, counsel, I'm inclined, because of the age of the case, and I don't think it's very likely that Oklahoma will take him back, or even if he went back, he would complete. I think his ability to, if he had just done one of these programs, one of these evaluations, that might have been something. But I made it very clear that I wanted him to get these programs started 90 days from his last show cause, and he didn't, and he should have known what the ramification or what the consequence of that would be, and he didn't even do one. And I just need, there just becomes a point with these cases where they need to be terminated, and I think this case is one of those. So I am going to order that he serve his sentence. He's had his sanction. I'm not going to reduce his sentence. I'm going to have him serve it, but he's almost got, by the time your journal entry gets done, you'll have 6 months of your 12-month sentence served. And then you may go to RDU, and that's usually 90 days. And I'm sure you can earn your good time credit, which is 20%, which would be at least 2.5 months. And then there's program credits that you can do. Last I knew anyway, up to 90 days or 6 months off your sentence if you just do certain, participate in certain programs. So hopefully they can offer you some things. I'm going to terminate your probation. So what you do further, is really up to you in terms of what parole requires of you and where you go and what you do. The only obligation that you're going to have with this court is to pay off your case, because I cannot waive the court costs and the fees. They're a judgment, and they're a judgment when ordered, and they're a judgment that's collectible indefinitely. I am going to do a payment plan for you to pay $10 a month. If you don't do that, if you're unable to do that, it can be turned over to collections, but I don't think it's going to have that much of an effect on you because you're not going to be in very long. And it is possible that DOC will just pay out county to keep you until you complete your sentence. I'm not really sure, but it's probably not going to be much past RDU. But at any rate, I need to order that you serve your sentence. There's no reason to reduce a 12-month DOC sentence. I don't think I've ever done that. You don't have very much time left and you'll be finished with the case. I believe those programs would help you, but whether you would get to them every week and whether you would complete them and report it and get sustainable employment and make your payments, that's just too much of an unknown. And I think we've given you enough opportunities, and unfortunately you didn't put yourself in a situation for whatever reason to accomplish that. So, all right, you have 14 days to appeal. Is there anything further, counsel?
I don't believe so, Your Honor.
All right.
Not from the,
All right. Is there anything that you want to add, Ms. Stanfield, or you've never really directly supervised him to speak of? All right.
The only question,
Yes.
the only question I have, are the attorney fees waived?
Yes, it's
Okay.
all waived. Yes. All right. If there's not, that means you haven't been assessed any additional costs, sir. Mr. Camp. All right. If there's nothing further, we are adjourned. Thank you. All right. Good afternoon. We're going to go on the record in State of Kansas versus Melissa James, Greenwood County District Court case number 2024 CR 225. The state appears by and through Ms. Gillette, the Greenwood County attorney. Ms. James is appearing by Zoom separately from her attorney, Mr. McClendon. I've received the pre-sentence investigation report that was prepared by Ms. Teal, who is retired. She submitted this report on August the 19th, 25, or maybe it was finished up and submitted by Ms. Morgan. I'm not sure, but Ms. Morgan's here on behalf of Court Services. There is no real criminal history. I mean, it's an I, so I doubt there's much objection to that, but Ms. Gillette, any dispute with the court finding criminal history I?
No, Your Honor.
Mr. McClendon?
No objection, Your Honor.
Okay. Now, the only thing, Jessica, we've got a level 5 drug that is mandatory Senate bill, and then a DUI drug, which has separate provisions. That's a first offense misdemeanor. But I'm noticing on the SASE that there is an X by the arrow for high probability, and it's highlighted. Maybe I highlighted it. But and then there's low probability. So I assume she had to find high probability for her to be Senate bill eligible.
Yes, Your Honor.
All right, that was just a little confusing. Very good. All right, recommendations from the state.
Your Honor, she said this is mandatory Senate Bill 123. The state is recommending the standard box in which she falls. That includes up to 20% good time credit, 12 months post-release supervision should she serve any time on this. She is recommended to go on community corrections for Senate Bill 123 treatment. The second count in this is DUI. It was count 2 on the complaint. The driving under the influence is a first. It would have a $750 fine as a minimum fine recommendation from the state. That normally has a 6-month underlying with a 12-month probation. No objection to that being concurrent with count 1. There are other provisions for DUI. On usually the first will allow those to be as the court finds.
Well, does she, on the 48 hours she has to do, has she,
They
does she have any credit for time served?
They changed that in the statute, Judge, when they redid it a while back. the first time no longer requires a 48-hour.
I know, I'm still pretty inclined to give it. Does she have any credit for time served?
Her credit is 5 days from 12/12 to 12.
Okay, well, she's got credit.
Mhm.
I don't know why they did away with that. That's ridiculous. As far as I'm concerned. All right. And then
There-
$750 fine. The other question is, do you think the drug and alcohol requirement for a DUI that the Senate bill evaluation and treatment would be able to substitute needing an additional drug and alcohol?
Yes,
Okay,
you
all
can
right.
use the SASE. She'll have more intensive treatment with the SASE than she's gonna have on a drug and alcohol eval. There is a KBI lab fee of $400, court cost, DNA database fee. There is a Senate bill reimbursement and booking and fingerprint fee. We'd ask the court to assess those costs with the $750 fine. Since she is being sent to community corrections for her supervision, $250 of the DUI fine is normally sent over to the Community Correction Supervision Fund. There's a separate box to check for that since they will be supervising her. Then we'd ask the court to inquire pursuant to Robinson and Biz attorney and application fee. On count 2, I've already kind of announced what that sentence is. Again, no objection to them being concurrent. She does have the 5 days to award. And I believe that is the bulk. We'll need to set up a payment plan for her.
Okay, sounds good. Yeah, I should have looked here on the PSI. It is, she does have 5 days. All right, Mr. McClendon.
Judge, we'd ask that you follow the state's recommendations, and particularly on the 2 counts, we'd ask that they run concurrent with each other as they did arise out of the same instance. That is all, Judge.
Okay. Ms. James, is there anything that you would like to say before I impose your sentence? Okay,
I don't really know what to say, but I've been sober ever since I got out, so
okay,
I haven't touched it, don't want to, don't need to, and
okay.
I'm
What'd
pretty
you
happy
get out of? Where did you go to rehab?
I didn't. I
Oh,
just stopped.
okay,
It's not worth losing my life, and it costs way too much anyways. Especially with now that I got a felony and everything, I'm not worth. I don't want to do it again.
okay, okay. How old are you?
44.
Oh, okay, you look so young. All right.
Thank you.
And are you currently employed?
No. I was, but my boss sold his company because he was sick, and I haven't got it. It happened back in June 20th, so I'm on unemployment because I didn't want to go out and find a job in case whatever happened with my sentencing. I didn't want that to affect my new job, and I'm getting ready to move because I have to be out of the place that I'm living at now by September 1st, and I'm was planning on moving to Oklahoma, but if I'm not able to, then I got to find a place real fast. But my boyfriend lives in Oklahoma, so but
Okay,
if that's going to affect stuff, then I got to change whatever
well,
I'm doing. So
yeah, it would foul up your Senate bill treatment. You wouldn't be eligible for that. And they could compact you, but you don't compact as fast if you're not a resident at the time of the offense and at the time of sentencing. So it takes a while to get the transfer approved and to happen. So I don't know. You are going to have to talk to your community corrections officer about the possibility of all that. I wouldn't plan to be there by September 1st. I can tell you that. But if you want to develop some kind of plan that you could substitute some kind of treatment, an evaluation, you're still gonna have to fulfill all your probation requirements. I'm not
Yeah.
going to object to you being transferred as long as you have a, you know, a decent residence to go to and a job and all of that, but, I can't tell you that they will be able to do that or be willing to do that. Okay?
Yeah, that's understandable. And
Okay.
I'd be able to come up here, drive up here anytime I needed to do see my probation or whatever I needed to
Right.
do.
But if you're not a resident, they will not do the state funded treatment.
Okay.
So you just have to see how that all shakes out. If you have any
Okay.
questions, you need to talk to Mr. McClendon. Okay?
Okay.
All right. For the crime of possession, of, I think it was meth. I always forget which drug.
It was meth.
Okay. For the crime of possession of methamphetamine, a level 5 drug felony, I'm imposing a sentence of 11 months with Department of Corrections. You do qualify for mandatory Senate bill treatment, and I will order that you participate and complete Senate bill treatment unless there's some request for a review of that by someone at some point. That allows your probation to exist for up to 18 months. Your underlying sentence, if you violate probation and are ordered to serve it, would result in 12 months of post-release, but you could earn up to 20% good time credit on your sentence. I am going to award you 5 days of jail credit, and on the additional count 2 DUI, I'm imposing a sentence of 6 months, a $750 fine and costs. I will place you on probation on that. I will run it concurrent as recommended, but I am going to order that you do 48 hours as a condition of the probation, but I will give you credit from your 5 days so that you don't have to serve an additional 48 hours. Standard conditions of community corrections. No drugs, no alcohol, follow any treatment recommendations. They have the ability to UA you. Upon reasonable request, you must participate or offer blood, breath, or urine. Obtain employment, maintain employment, make monthly payments. What I usually tell everybody to do is take the total amount of what you owe and divide it by your months of probation, and that should be your monthly payment, or at least your goal. If you can't make the full amount, make sure you make some kind of payment, because you can be extended, or sometimes the case is referred for collection if you haven't paid it off. But what you don't want is a revocation filed because you're coming to the end of your probation and the case isn't paid off. So, all right. They need to know where you're living. You have to have permission to move, or they have to basically give you permission to move. You cannot go visit another state without a travel permit. So that's interstate compact rules. The state of Kansas has been fined up to $1 million before, if they violate interstate compact rules. So what that means is states that have people on felony probation or parole cannot send them or let them go to another state without permission, without knowledge and permission of that state. They may do curfew. They'll go over all of these things with you and have you sign an agreement where you initial all of the conditions so that you're confident that you know and or you have the conditions in your possession to look at so you don't violate them. I do have to assess a lot of fees and costs The KBI lab fee is $400. That helps supplement the drug testing people, to keep people employed, to do the work. I have to assess court costs. I had to assess the $750 fine on the DUI. I have to assess a $200 database fee. They will take a swab from you, profile it, and put it in the law enforcement database. That's required on all felonies, even felony DUIs. There are some community correction supervision fee that adds up to about $225. There's $100 bids fee that I assess. There is a $45 Greenwood County booking fee, and there is a $300 Senate bill fee. So all of that adds up to $1,488. So you're looking at least $80 or $85 a month that you need to pay.
And that's why I got clean and sober right after I got out of jail.
Yeah, actually, that doesn't include your $750 fine. So it's more than that. So it's more than 100. So take a look at that and just try to stay on top of it. If you don't get a job right away, start doing some community service and see. I will allow you to utilize community service to work off your fine, but it's at $6 an hour. So for every hour you volunteer, you get $6 off your fine. So most people do better by going to work, even if it's fast food, and getting paid and paying their fine than the time that they have to spend volunteering. I will waive your attorney's fees because you're unemployed by no fault of your own, but you do need to get some employment. And your first priority has to be to work through this case and get this behind you. But if you can work out some Oklahoma transition, I'm fine with that too, and with transferring your supervision. All right, you have 14 days to appeal. You cannot possess any firearms.
I don't like them anyways.
Okay. That's always the case when you're on probation, but when you've been convicted of a felony, it's about a 7-year stint. And I always tell people, don't ever get a firearm for any reason, self-protection or hunting, unless you check with the Attorney General's office and you're certain that you wouldn't be violating the law, either state or potentially federal. Okay?
Mm-hmm.
All right, you can expunge this felony. So when you finish probation successfully, you have to be successful. You have to have your case paid off. Then 2 years after that, you have no new convictions or charges. You can have this conviction removed from your public record. Now, it doesn't mean that your criminal history doesn't count against you in the future if you would have a new case, but it does mean that you can apply for most jobs with most private industries and you don't have to divulge the conviction, and they shouldn't be able to find it either by usual resources. There are exceptions to that. They're in the statute. Things like certain jobs that involve fiduciary duties, security clearances, police work, certain types of professions, the gaming commission, they have a right to look at expunged records. But for the most part, most places that you would apply to work, they don't have access to expunged records. So the legislature has done that, and they require that I, at the time of sentencing, advise you of your expungement rights. Do you have any questions? Okay, we're going to put you
No,
in
ma'am.
a breakout room with Miss Ashenfelter of Community Corrections. Hang on just a minute. And she will direct you on where to report, how to report, and what your next steps are. Ms. Gillette?
May I check the box to have $250 into community corrections of that fine,
Yes. Mhm.
Your Honor?
That's not an additional fine. That's just breaking up your fine for part of it to go to certain types of funding through probation. I think I don't know. They help indigent people with something with it, treatment or something. Okay, Mr. McClendon, anything further?
No, Your Honor.
All right. If there's nothing further, we are adjourned, and if you'll hang on and go into that breakout room, I would appreciate it. Thank you.
Thank you.
Roberto Ambrosino, who are you here for?
Good morning, Judge. I'm here for Cassandra Oberlender. I believe she's in the Zoom waiting room for a restitution hearing. She lives in Colorado.
All right, state on Cassandra Oberlender. It's for a restitution hearing. Are you all prepared to proceed?
Yes, Judge.
All right, Cassandra Oberlender. And do you all, first of all, do you all have a restitution amount?
We have a witness here, Judge.
Oh, okay. Court is calling 2024 CR 012530 State versus Cassandra Oberlender. Can I have parties announced for the record?
Lauren Espinoza for the state.
For the defense?
Roberto Ambrosino.
And are you Cassandra Oberlender?
Yes, ma'am.
All right, any objections to Miss Oberlender appearing by Zoom? And defense, I'm assuming you have no objection to your client appearing by Zoom?
No, Your Honor.
And Miss Oberlander, you do realize that if you wish to appear in person for this hearing, you can appear in person. Do you understand?
Yes, ma'am.
All right. So do you consent to having this hearing by Zoom?
Yes, ma'am.
All right. State, do you have any witnesses?
Yes, Your Honor. State closed Aida Ramos.
Could you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yep.
All right, you can lower your hand. Make sure you keep your voice up for the court reporter to hear and for the persons on Zoom to hear. If you'll state your name for the record.
Aida Ramos.
All right, state, you may proceed.
Ms. Ramos, what is your occupation? I'm a realtor, property manager. Your property manager for which property? Simple Realty Services. Is Simple Realty Services renting to or were they renting to a tenant by the name of Miss Oberlander? No, that was her boyfriend. What is her occupation? Riley?
Okay, so guys, I'm so sorry. You are gonna have to speak up because I'm having trouble hearing. And the court reporter, I'm looking at her real time and she's having problems hearing. All right, so if you'll repeat your last question, please.
Yes, what was Miss Oberlander's boyfriend's name?
Riley.
And was Riley a tenant with the property?
Yes, ma'am.
What property did he reside at?
1238 Cold Lake Drive.
Was there an incident involving Mr. Riley and the property, or I'm sorry, Miss Oberlander and the property?
Yes, ma'am.
What incident was that?
She burglarized.
Was there
She broke
damage?
in.
She broke in to which property again?
1238 Cold Lake Drive.
What damage was caused, if any?
Well, she broke in and she broke the door of the garage and went in, and I have the video where, because we had cameras inside, and she went in there and she also stole money. That I also have where her boyfriend Riley texted me and she said that he
Objection, hearsay.
Sustained.
So you said she broke in through the garage, is that correct?
Yeah, the garage.
Did you have the garage fixed or replaced?
Yes, ma'am. I do have for the invoice here. I'm sorry.
Did you get an estimate done for that repair?
Yes, we did.
Through which company?
Alpine Property Group.
And how did that happen?
Well, after we made the report, you know, I did speak to the owner and he requested for us to have.
Objection, hearsay.
All right, so just talk about what, may I ask a question? Any objection?
No.
Any
No, Judge.
objection?
No, Judge.
All right, so what damages are you alleging was caused by Miss Oberlander?
The broken of the door of the garage.
Okay,
and
the garage door, what else?
Camera.
And the camera.
Mhm.
What's the price to repair the garage door?
Like here, it was $850 for the door and the installation, and the security system was $650.
All right, so how much for the garage door?
$850.
$850. Does that include the price of the door
And the
and the
installation.
installation?
Correct.
And how much for the camera?
It was $650.
$650. State, any other questions? Defense, any questions?
Yes. Isn't it true that Riley, the actual tenant to the property, had a key to access the room where the camera was?
No, not that, no. Only to his room. There was an attachment there where he actually lived. The door where she broke in, it was on the other side.
So in what manner are you saying that he broke the door or that she broke the door?
She broke in. Well, I don't know what she did because the camera was inside the garage, because we had cameras inside the garage.
Isn't it true that she was given, or I'm sorry, that Riley was given a key by someone named Sergio that actually allowed him to have access, even though I guess there's some dispute over whether he was supposed to be entering into that property?
No, he only had the key for his area where he lived.
When did you repair the property after that?
The date here of the invoice is for June the 1st.
June the 1st of 2025?
2024.
Okay. This incident actually happened several months before that, isn't that correct?
So the incident happened. It happened, well, we repaired it after the break-in.
Right, but I mean, you allegedly let the house go unrepaired then for several months.
Well, this is where I have the invoice. I got it from the owner,
Okay, why isn't the owner here today to testify?
because I'm the property manager.
Okay, so you didn't actually pay to have any of this fixed?
I didn't pay for it. It was the owner, the company, which is Simple Realty Services.
Okay, and so you don't know anything that wasn't secondhand information that was told to you by somebody else?
No, sir.
Okay, pass witness.
All right, any other questions?
I think we'll see your honor.
Defense, any other questions?
No.
No, Your Honor.
All right, thank you. State, any other witnesses?
No.
All right, oh, I'm sorry, you may have a seat. Defense argument?
Judge, my client contends that there was a key to enter the property. Basically, this was a room that he was renting and he had access to the whole property, and that she, yes, did go into that particular room without consent, and she did damage the camera. So we do not contest that amount, but we do contest the amount that's being alleged with regard to entering the room that the camera was in. She basically states that she would have had access to it.
All right, state. So the defense is stating that they have no objections to the amount of the camera, which is $650. So the court is ordering the $650 restitution because the defense does not dispute that. Would you like to speak to the door for $850?
Your Honor, this offense is for the burglary of a building, which was through the garage. Because there was the camera on the interior, we did not see the exterior entry. However, despite them arguing this key was given by somebody else, this damage was caused. We would urge the court to order this restitution because the damage was done to the garage.
All right. So this is what the court is going to do. What is the owner's name of the property?
Either Ramos.
All right, the court is, in this case, the court is ordering that restitution be paid in the amount of $1,500 for the price of the garage door and the price of the camera. All right, is there anything else?
Judge,
can I get the name of the, where that's being paid to?
State, if you'll give her the name of the property owner, please. All right, thank you, counsel.
Thank you, Your Honor.
All right, could I have the parties on Amber Marino? Hello. Hi. Thank you for dressing appropriately for court. All right, the court is calling 2025 CR 006931, State versus Amber Marino. Can I have parties announce?
Lauren Espinoza for the state.
And are you Miss Marino?
Yes.
Counsel, have you received all discovery? Did you review it with your client?
I did.
Court will find that the state is in compliance with discovery. Ms. Marino, did you review the application for deferred adjudication with your attorney?
Yes.
Did you understand it and sign it?
Yes.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes.
Counsel, are you waiving the reading of the indictment?
I am, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Ms. Marino, did you review court admonishments with your attorney?
Yes.
Did you understand it and sign it in all the appropriate places?
Yes.
You're charged with criminal mischief, $2,500 to $30,000. That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state will call in the right to remain silent. By entering into this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty, sentence you up to 2 years in the state jail facility and up to a $10,000 fine?
Yes.
Counsel, has your client been able to provide you with any defenses?
Yes, she has, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
I do.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes, I do.
Ms. Moreno, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No.
Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen?
Yes.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes.
According to the plea bargain agreement, there's to be a $1,000 fine probated. The state is recommending deferred adjudication. There's to be restitution to the complainant in the amount of $1,764.08. Did you understand that to be the plea?
Yes.
Defense?
Yes.
State?
Yes, Your Honor. Can it just be noted that this restitution has to be split amongst 3 co-defendants? So I guess joint and several liability for that restitution amount?
All right. So here's the thing with that, and I think your attorney probably explained it to you. If there are other people who are part of this, all of you owe that amount.
Yeah.
If for some reason, if it's involving let's say it's involving a total of 3 people, I don't know how many people that are alleged. If 2 people decide they're not paying it, then you have to pay the entire amount. Do you understand?
Yes.
So I know that sometimes when people enter pleas, they, in their mind, they'll say, oh, let me divide this restitution amount among 3 people, and then I only owe that amount. Do you understand?
Mhm.
Now, if the other parties are paying their sum, the person that's owed this money, they're not going to be able to get $1,764.08 from everyone. It's just, that's the total amount. Do you understand?
Yes.
All right. Does that clear everything up, State?
Yes, please.
All right. Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Council, are there any such motions? Outside the agreement, the state is requesting that your community supervision be for a term of 4 years. There be a TAP evaluation, 100 hours of community service restitution, no contact with Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yeah.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
Guilty.
State any evidence?
Yes, state offers what has been marked as State's Exhibit 1.
No objections, Your Honor.
All right, and state you may be excused. You're welcome. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in, the right to remain silent?
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence state's exhibits 1 and attachments, and the court will review the same. All right, after reviewing state's exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing? Anything you wish to say on behalf of your client?
Yeah, we spent a lot of time yesterday, going over everything, and she's agreed to accept responsibility. At time to plead guilty, and I suggested to her to plead guilty, because she is guilty, rather than try to hide behind no contest. But so that really demonstrates an acceptance of responsibility. A situation where she was just overwhelmed by what was going on in her life, and something snapped yesterday. I really characterize this as average behavior. She's never been in trouble before, 22 years old. So we'd asked the court to give her a chance on deferred and follow the plea agreement.
Right, you say she's 22? All right. So let me ask you, who is Roman Villarreal to you?
That's my brother.
All right. And your relationship to Valerie Marino?
That's my sister.
All right. And how old is your child?
She's 3.
3? All right. So let me explain something. And this is what I would always tell my clients who are on the CPS side, right? When people have a child together, that's the person you chose to have a child with, right? It's very important that you're able to co-parent, because even though you're no longer with that father and maybe you've moved on with someone else, your child still needs to see what healthy relationships are. And I know your attorney is saying this is out of character, but if you can just internalize and think about how your child was feeling with all these adults, these grown people just screaming. And this is what I've learned. And you've done family violence cases. This is what I'm sure your attorney has probably told you. If he hasn't, I'm going to tell you. During child exchanges, unless this is like a Hallmark movie, don't bring your significant other with you for a child exchange. I have never seen that work out well. So by the same token, if the father of your child is coming to pick up his child, he shouldn't be bringing his girlfriend with him. And if you're going to pick up your child, you shouldn't be bringing your boyfriend or new husband or whoever it is with you, because tensions just rise. And if there's an issue where people are concerned about their safety during custody exchanges, that's when you say we're going to meet at a substation or meet at the police. You understand?
Yes.
But from reading everything, I see that there were issues going on and maybe the child needed help and all of these other health issues going on. So the $1,000, how much are you able to pay per month towards that? And here's the thing, give me a reasonable number, because sometimes people think I want to hear, oh, I'll be able to have $1,000 in 20 days. If that's not you, that's not you. It's just that I'm going to be placing you on deferred adjudication. I'm going to grant your application, but you're going to need to be able to let the state know, and I'm sorry, the probation officer know how much reasonably you can pay a month, because this has to be paid off. And since one person is your sister, the other one is your boyfriend, you know, usually your mother will say, hey, you better help your sister pay this off. So reasonably, what do you think you can pay per month towards this amount?
I can do 100.
Okay. All right. And was CPS involved at all?
No, Judge.
All right. This is what the court is going to do. The court is going to sentence you to 3 years deferred adjudication. Are you employed?
No.
All right. So how are you supporting yourself?
Well, I'm getting child support, and
Mhm.
my boyfriend would be the one to financially.
Okay, here's the thing that, you know, as a side note, you never know if a boyfriend is going to be around for the long haul. You never know if somebody has a girlfriend, if they're going to be around for the long haul. So you need to be able to say, because you have a child, you need to be able to say, you know what? If he were to leave, how am I going to support myself? Will I be able to provide a roof over the head for me and my child? You understand?
Yeah.
So you have to calculate that. All right. In this court, I require that people have employment. All right. So there's to be regular reporting by Zoom or in person, regular random UAs, proof of employment within 45 days. There's to be no employment as a home health care provider or with minors. There's to be restitution of $1,764.08 to the complainant. Are you all able to do child exchanges at a location different from this location?
She'll have to answer that, Judge. I don't know how she's doing that now.
We're doing exchanges at the police station on Sesame.
Okay, all right. So for now, you can't have contact with that specific address. State and the complainants don't want her back at the address, correct? All right, so you can't have any contact at that address. If there's an emergency that comes up with your child and it's at that address, then you'll probably have to call the police or somebody for a welfare check. Your attorney will let you know what to do in that situation, okay?
Okay.
So there's to be no contact with the location. And at some point, if things go well, the complainants may decide that it's okay for you to have contact at that location. All right, there's 100 hours of community service restitution. I'm going to order anger management. Once you've completed anger management, 50 of those hours will be deemed satisfied. And the remaining 50 hours will be satisfied once you've completed parenting classes. And I'm going to order parenting classes. Field visits 1 time per month for 3 months. And there's $1,000 fine, and that will be probated. And restitution is to be paid at $100 per month. Probation, is there anything else? No, there wasn't a request for a no contact with him, just the address.
I have one more thing, Judge.
Yes.
What would you set the supervisory fees at? Set them at the minimum because of.
In regards to that, legally, now that they've changed things, she'll have to fill out a form. And once she fills out that form saying that she's indigent and provides proof, I'll receive notice of that, and then I'll be able to make a decision on that.
And can she get that form from probation to fill out?
Yes.
Okay.
All right. And what I can tell you, supervisory fees, they help probation run their operations. Okay.
Okay.
All right. Is there anything else you need from the court? Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yeah.
All right, we can go off the record. Here's the thing: to be successful on probation in this court, communication is key. If you have an issue, let probation know about it. If you feel they're not addressing it, you can always come back to the court and address it with me. Do you understand?
Yes.
All right, good luck to you. Make better decisions, okay?
Thank you.
All right, you're welcome. Thank you, counsel. All right. Eleanor Arzola. Are y'all ready to proceed on the motion? All right, the court is calling 2016 CR 5076 State versus Eleanor Arzola. Can I have parties announce?
Rick Pena for the state of Texas, John Pettis for defense.
And are you Miss Arzola?
Yes.
All right, did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it?
Yes.
Are you the same Eleanor Arzola who was placed on deferred adjudication in 2016 CR 5076 for the offense of burglary of a habitation on August the 22nd, 2017 for a period of 3 years and extended for a total of 6 years? Is that you?
Yes.
All right, state.
Yes, Your Honor, we're here this morning on state's motion to enter adjudication of guilt and revoke community supervision. Violation of condition number 46. On or about the 7th day of August, 2025 in Bexar County, Texas, the defendant Eleanor Arzola did then and there fail to comply with biweekly urinalysis on IVR line in violation of condition number 46.
How do you plead to that? True or not true?
The state will waive the other violation.
Any objections?
No objection, Judge.
Did you understand by pleading true to violation of condition number 46, the court could find it true, grant the motion, find you guilty, sentence you up to 20 years in prison and up to a $10,000 fine?
Yes.
Knowing that, do you still wish to plead true to violation of condition 46?
Yes.
Court will find violation of condition number 46 true. Is there a proposed agreement?
There is, Judge.
And what is the request?
Their agreement is to revoke her probation, adjudicate her guilty, sentence her to 2 years TDC.
All right, has she done anything on probation? Other than just being on probation?
She went to my office with that. She's completed patterns intervention. She's completed a significant amount, Judge. Addiction just got hold.
Probation?
Did complete 123 days in my office. She did a outpatient program as well, the IPP, or parenting class. Oh, I'm sorry, the IPP, it says there was a violation of program or services. But the my office complete, there's some classes but complete. It was on the GPS for a while. That needs to be complete as well. Total credit of $129 for her assessed fees of $5,154.
All right. The court is going to grant the motion. The court will sentence you to 4 years in the prison, give you credit for any time served, credit for any time served and successful completion of inpatient treatment. So if she was placed in the facilities and she successfully completed those, she'll have credit for those. All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney?
Oh, yes.
All right, because I found you guilty and because I've revoked your deferred adjudication, you do have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you were on deferred adjudication. Do you understand? And I'm going to also request a therapeutic community for you. I can request it for you, but you're going to have to request it as well because I do not have the authority to force them to place you in that program. Once you're released from the prison, if you can't find a sober support house or anything of that nature, just let me know and come back here and I'll pick up the phone and call someone to see if we can get you help. All right?
Thank you.
All right.
Maybe.
Yes. Yes.
And we now recall House number 23, DCCR 173, the state of Texas versus Joshua Mendez. The defendant is present with his attorney. and the state's attorneys. The court has received a message from the jury that the jury has reached a verdict in this punishment phase of this trial. And I'm going to ask the bailiff to please bring the jury forth, and we will accept the verdict. The record shall now show that the jury is seated in the courtroom. Ms. Matheny, as foreperson of the jury, we have received a message stating that the jury has reached a verdict in the punishment phase of this trial. Is that so?
Yes.
Is this verdict or verdicts unanimous decisions made by the jury? That is, ones that are agreed upon by all members of the jury.
Yes.
Do any of the jurors disagree with your foreperson's representations? No disagreement is indicated. It does appear to be a unanimous decision or decisions on behalf of the jury. As before, if you would be so kind, pass the documents to the bailiff. You may be seated. Thank you. And the court will review for proper form and publish the verdicts. In cause number 23, DCCR 173, count 1 in the state of Texas versus Joshua Mendez, we, the jury, assess the defendant's punishment as to count 1 of the indictment at confinement in the institutional division of the Texas Department of Criminal Justice, in other words, prison, for a term of 10 years, signed by the jury foreperson. As to count 2 in cause number 23, DCCR 173, the state of Texas versus Joshua Mendez, we, the jury, assess the defendant's punishment as to count 2 of the indictment at confinement in prison for a term of 10 years, signed by the jury foreperson. The verdicts are received and made a part of the record for all purposes. You may be seated. Ladies and gentlemen of the jury, at the beginning of the trial, I placed each of you under a number of instructions, and at this time, I am releasing you from those instructions previously given to you. One final instruction, though. After you are discharged here in a moment, you are released from your oath of secrecy. You are free to discuss this case in your deliberations with anyone. You are also free not to discuss the case in your deliberations with anyone, and you have every right to maintain your silence unless otherwise ordered to do so by me. Once you are discharged, Ellie, by the way, has documentation for you if you need it for work or school or other purposes to show that you were here this week. Once you are discharged, I've got to take up some matters with the attorneys, and they will be released in a few minutes. They always like to get some feedback or input with jurors if you're willing to stay and speak with them. And again, they will be released in a few minutes. And that always helps them be a better lawyer to get feedback from you. But you are free to discuss this or not discuss this with them as you choose. And you are free to discuss or not discuss these matters with anyone as you may choose. I want to thank you for your jury service, and it's never an easy job. It's not supposed to be easy to make judgmental decisions about others, but it's the way the United States of America works. We are the leading government on this planet because of self-governance. And the Constitution begins with we, the people. All of us are in it together. And the decisions you make will affect others. And that's why it's so important for you to do your job when you are called upon and to do it properly under the law. It has been an honor working with you, ladies and gentlemen. I hope to have the honor to work with you again in the future. But until then, may God continue to bless Jefferson County and her citizens. and you are excused. And also alternates, thank you as well for your vigilance. And hopefully next time you're going to be in the jury box. And again, the lawyers will be out there in a few minutes if you wish to speak with them. Thank you. All right, the jury has exited. Any legal reason why judgment should not be pronounced at this time in these two cases?
No, Your Honor. Not from the state yet.
One issue we need to address?
Yes, sir.
All right, Article 42.08 of the Texas Code of Criminal Procedure is going to be directly applicable to the circumstances in this case, which provide for cumulative or concurrent sentences, cumulative, consecutive, or concurrent sentence. When the same defendant has been convicted of two or more cases, judgment and sentence shall be pronounced in each case in the same manner as if there had been but one conviction concurrently, except as provided in subsections B and C. In the discretion of the court, the judgment in the second and subsequent convictions may either be that the sentence imposed or suspended shall begin when the judgment and the sentence imposed or suspended in the preceding conviction has ceased to operate consecutively. Or the other option is that the sentence imposed or suspended shall run concurrently with the other case or cases. However, that the cumulative total of suspended sentences in felony cases shall not exceed 10 years, and that's not applicable because we're talking about suspended sentences, probation, which is not eligible in this case. All right. So what says the parties as to this matter?
The state would ask you to run these consecutively. We believe that your authority is proper under what you've already cited. In addition to 3.03 of the Texas Penal Code, specifically, the exceptions are provided under paragraph B, subparagraph 2, when we deal with an indecency with a victim under the age of 17. The judge, as I argued with the jury, but for the father's actions that day, this would have been so much worse. And I've always felt like my hands were tied dealing with a 10-year punishment on this third-degree felony. I think it's more appropriate that what's done in a just and fair manner here is to stack the sentences.
What says the defense?
Your Honor, in considering there is no doubt that you can run or stack these sentences under 303, 3.03, and also 4208. I'd ask the court to take judicial notice, one, of the other indictment. If you want to take the state's arguments in reference to only be limited to the 10 years under this clause, there's another indictment attempt to commit aggravated sexual assault, which is a second degree. They elected prior to trial to only go on the indecency, which was 2 to 10. They had the opportunity, if that was their position, that he was stopped from any further possible crimes, aggravated assault, then they could have gone on the attempted, which is a second degree, 2 to 20. But in addition to that, Your Honor, when you consider whether or not you want to stack it or not, please take into consideration that Mr. Mendez does not have a criminal record, not even any misdemeanors. That prior to this, that he led a productive or tried a productive life, and that he worked
He provided for people that were around him. I will represent to you that he was under current child support obligation for his first child, which he was complying with. I will also submit to the court that if you look back at his jail records, when he's been sitting here for 2.5 years, there's only one entry, and discussed it with the state. And that was that the guards went in there because he was so quiet. They wanted to make sure he was okay. And that's the only discipline that he had in Jefferson County. So he's complied with the rules and regulations. Your Honor, it is his belief of what he did not do, and he had his time in court on that. But if you take what he has done in his past, and I know you have to take into consideration what you heard in this trial. I think it's consideration that, and we request that these run concurrently for his sentence.
All right. Under section 3.03 of the Texas Penal Code, called sentences for offenses arising out of the same criminal episode, as the court finds occurred in the circumstances in this case, under subpart B of that section of the Penal Code, it is stated by the legislature that if the accused is found guilty of more than one offense arising out of the same criminal episode, the sentences may run concurrently or consecutively if each sentence is for a conviction of, under subpart B, subpart 2, subpart A of that provision, an offense under section 21.11 if committed against a victim younger than 17 years of age at the time of the commission of the offense, regardless of whether the accused is convicted of violations of the same section more than once or is convicted of violations of more than one section. In other words, the court has the option under law to run these sentences concurrently or consecutively, since the jury found the defendant guilty of 2 separate counts under this cause number 23 CR 173, each of those counts alleging indecency with a child, that is, exposing the defendant's genitals with the intent to arouse or gratify the sexual desire of any person, knowing that a child younger than 17 years of age was present. And the other count, intentionally, with the intent to arouse or gratify the sexual desire of any person, caused the child younger than 17 years of age to expose her genitals. Okay. The statute has provided an option for the courts in the dissemination of convictions, even when there is more than one conviction out of the same criminal episode. Here, the jury found the defendant guilty of 2 separate crimes out of the same criminal episode and assessed his punishment at 10 years confinement in prison on each case. Section 21.11, dealing with indecency with a child, is placed in these options for a judge to consider in determining whether the punishment is concurrently or consecutively made, because of not only who we are dealing with, and that is children younger than 17 years of age, and the type of crime we are talking about. The state made comments concerning the loss of innocence of the child. How do you put a number on that? What is the value of the loss of an innocence of a child? I believe we consider it, there is no value you can place on it. When it's lost, it's lost. And it's special because a child should not have to deal with issues such as loss of innocence. But it happens, and it happens in this court all too often. Also, each act of indecency, as found in this case, are separate acts, separate commissions of a crime. Do you get to look at it as a defendant? And what we're talking about is not only the circumstances of this case, but what message is sent in sentencing to others who may consider committing these types of offenses. That you get to commit as many indecencies as you want, and then it'll be packaged up, all for the price of one. Each act of indecency has its own cost to pay. That's the way this court deems. That's the way the people who have put me in office believe. The law provides for it. Children should not be harmed. When that happens, the price shall be paid. Not only the cost of the particular case, but to deter and send a message to anyone else who considers harming a child by indecency. These are two separate events. The defendant is convicted of exposing himself to the child, then causing the child to expose herself. Those are two separate acts. They will be punished on this court's watch in two separate sentences. Joshua Mendez, you came before this court and a jury, entered pleas of not guilty to counts 1 and 2 of in cause 23 DCCR 173, an indictment of this by the Jefferson County Grand Jury, charging you with 2 counts of indecency with a child by exposure. These are third-degree felonies, carrying with it up to 10 years imprisonment on each case. The evidence was submitted. The jury was charged by the court. After deliberating, the jury returned verdicts, finding you guilty in counts 1 and 2 of indecency with a child by exposure. Thereafter, evidence was presented, the jury was charged, and after deliberations, the jury assessed your punishment at confinement in the Texas Department of Criminal Justice's Institutional Division prison for a term of 10 years as to each count. It is therefore the judgment of this court that you are guilty in counts 1 and 2 of cause number 23 DCCR 173, and you shall be punished in accordance with the jury's verdict. Mr. Burbank, is there any legal reason why sentence shall not be pronounced at this time against the defendant?
No, Your Honor.
Having nothing to say, it is therefore the order of this court that you, Joshua Mendez, having been adjudged guilty in counts 1 and 2 in cause number 23 DCCR 173, each count alleging separate instances of indecency with a child by exposure, and whose punishment has been assessed at 10 years confinement on each charge and conviction. You shall be imprisoned in the Texas Department of Criminal Justice's Institutional Division to serve 10 years confinement on each count as found guilty in this cause number, you shall be delivered by the sheriff of Jefferson County, Texas, to the director of the Texas Department of Criminal Justice's Institutional Division, or any other person legally authorized to receive such convicts, where you shall be confined for 10 years confinement in each case in accordance with the laws governing the Texas Department of Criminal Justice's Institutional Division. These sentences shall run consecutively. After count 1 has been completed, you will serve count 2. Each of these counts provide for confinement based upon the jury service of 10 years on each case confinement. And again, that adds up to 20 years total. So again, you will serve count 1, and at the completion of that sentence, you will be subject to beginning and completing count 2. And again, these sentences shall run consecutively to each other. You are now remanded to the custody of the sheriff of Jefferson County, Texas, until she can obey and carry out the directions and instructions of this sentence in each case. Your sentences will commence this day. You will receive credit for all time periods of detention as provided by law. Is there anything else to add by the state or the defense?
Yes, Your Honor. As part of, we have filled out the registration requirement set out by law. And number 2, Your Honor, because this was a trial, we also submitted the necessary certification that needs to be signed for his right to appeal on this.
Joshua Mendez, you now have reportable convictions or adjudications of crimes requiring you to register under Chapter 62 of the Texas Code of Criminal Procedure for sex offender registration requirements. You will be required to register in the sex offender registration program. And this is an application here on this registration admonishment, which you must sign. You and your attorney have signed this. Is this your signature here, sir, at the bottom?
Yes, sir.
All right. Please note you have reportable convictions or adjudications requiring you to comply with Chapter 62 of the Texas Code of Criminal Procedure, sex offender registration requirements. Failing to do so is a criminal offense that may result in prosecution. If you move to another state that has similar reporting requirements for sex offenders, you must register in that state. And failing to register will result in you being charged with a criminal offense or offenses. Do you understand your obligations that you have based upon the convictions in these cases, sir?
Yes, sir.
All right. Is there anything else to add from the state or the defense?
Certification off.
You have your rights under the law to appeal these convictions. Are you going to handle that, Mr. Burbank?
Probably not, Judge. I always allow a third party to take a look at. I can, but I always allow a third party to take a look at what I do.
You've discussed not only the sex offender registration, but also the appeals.
I have.
Rights that he has.
I have.
And his obligations for the sexual offender law that he must register in a regular fashion.
I have, Your Honor.
If nothing further, we are in recess in this case. Thank you.